Hello, and thank you for joining us for the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Greater Toronto Area family law firm, Feldstein Family Law Group. Both myself and the entire firm practice exclusively in the area of family law in the province of Ontario. Today, we are joined by a very special guest, Shazia Hafiji. Shazia is an associate lawyer at Feldstein Family Law Group, and prior to being an associate lawyer, she did her articles at our firm, and she was a summer student. Shazia prides herself in being client-focused and works to develop a meaningful relationship with her clients. Out of the office, Shazia enjoys traveling, cooking, eating movie, theater popcorn, and spending quality time with her family and friends, even though she should be a Leafs fan living in Toronto and she isn't a big hockey fan. Without further ado, Shazia, welcome to the show.
Hi, thank you, Andrew. Thank you for having me. I'm really excited to be here.
So today's show is all about a recent Supreme Court of Canada decision that deals with retroactive child support, or at least that's what us lawyers call it. What can you explain for the viewers, what does retroactive child support mean?
Yeah, for sure. So retroactive child support is child support that's paid for a period during which the support payer should have been paying child support, but wasn't or was paying a reduced amount of child support. So essentially, it's child support that is back paid.
Okay, now, what does this recent, or let's start with, what is the name of this recent Supreme Court of Canada?
It's called Michel and Graydon.
And what does it stand for? What is it about?
Well, I can walk you through the facts if you'd like. So Danielle Michel is mom and Sean Graydon is dad. They were in a common law relationship and they have a daughter together who in the decision they call her AG. The parties separated in 1994, and after that the child lived with the mom. The parties agreed right after separation that dad would pay child support approximately $341 per month. And that was based on an annual income based on what he reported as being $39,000. And then they paid child support, and then that was also formalized in a consent order in 2001. It was later determined that dad had underreported his income to mom for several years, and so in 2014, I believe, mom commenced an application for retroactive child support for the years 2001 all the way to 2012. And do you want me to continue?
That seems like a long way back. And
Yep.
before this decision came, my understanding is the leading case was referred to as DBS.
Correct.
And DBS usually talked about going back 3 years unless there was blameworthy conduct on the part of the payor. And was there blameworthy conduct in this case?
Well, I think that the court found that there was blameworthy conduct because the father had underreported his income for most of the years. So in 2001, for example, when he said his income was $39,000, the court found that his income was actually $45,000. So I think that spanned through all the years. And so the hearing judge in British Columbia, sort of the first level, allowed the mother's application, and he ordered that the dad pay $23,000 in retroactive support for all the years. And then the father appealed that decision, and the Court of Appeal set aside the hearing judge's decision and found in dad's favor. And then the mother appealed to the Supreme Court of Canada, which then brings us to our discussion today on the Supreme Court of Canada's finding.
What was it that the father did to hide his income?
I'm not really sure. Do you know?
I didn't see it from my review. I wasn't sure
either.
In a trial decision. So because they're finding blameworthy conduct of the father underreporting the income, and I'm wondering, when you look at a case like this, was underreporting something he did to hide his income? Did he not report all of it? Or was it there was a disagreement as to what some of his expenses were that he was incurring for his business?
Well, I mean, you and I, we see that come up in a lot of our cases. One of the interesting factors in this case was mom was reliant on social assistance throughout most of the years. And so her income would have been significantly lower than dad's income. And I think that would have been another factor in sort of comparing both parties' sort of standards of living over the years.
Now, part of what is also interesting is there's three decisions that went with this particular decision. So each decision agreed with what the majority said, but they arrived at different conclusions. And it may be interesting to see how the differing conclusions from the three different reasons lead into how the law will be interpreted by trial courts on a going forward basis. And the other thing that's interesting to note is that you said this was about $23,000 of arrears. Mm-hmm. To many of our viewers, they may scratch their heads and say, how does somebody go have a trial, then go to the Court of Appeal, and then go to the Supreme Court of Canada for $23,000? Now, I'm only guessing because this case came from the West Coast, so I'm not familiar with the lawyers on a personal level that were involved in it. But some Supreme Court of Canada decisions are because certain people have taken an interest in it and they fund the litigation themselves, because certainly nobody goes to the Supreme Court of Canada for $23,000. That would be the height of insanity from a cost-effective basis. So I want people to be aware of that. It's important to realize this was a novel legal issue. And what was the significant change that this case stood for from the previous retroactive support cases such as DBS?
Well, in DBS, the Supreme Court of Canada was interpreting Section 15.1 of the Divorce Act. And in doing that, they found that Section 15.1 precluded courts from granting an order for retroactive support in a situation where a child is over the age of majority. So if a child is now suddenly considered an adult and is no longer considered a child of the marriage, in those situations, under the DBS regime, a parent would be barred from seeking retroactive child support. What Michel and Graydon does is it clarifies that proposition, and it basically suggests that DBS, in fact, does not stand for the proposition that courts can only retroactively vary child support in situations where children are still children of a marriage. And so I think it really does change and clarify a lot of the questions we've had in the past.
Well, I think it's really important to understand, and I usually don't like to get technical on this show. I like to talk about generalizations. It's easier for people to follow. But the key distinction was twofold, as far as I could tell in this particular case, which is number one, Section 15.1 of the Divorce Act is the one that deals with the originating claim for child support. And that one specifically says, like you said, you have to be a child of the marriage. That means that when you're making that originating application, you need to be a child of the marriage at the time the initiating application is made. Whereas Section 17 that deals with a variation left out the wording of child of the marriage. And the Supreme Court of Canada interpreted that to mean, well, if they left it out, there's a reason they left it out in a variation application, such that when you're doing the variation, the child no longer needs to be a child of the marriage at the time of the application. And what's important to understand, and it's fascinating from this particular case, is you said these people are common law. Mm-hmm. And that's an analysis that I've just described as under the Divorce Act. So I'm sure you'd agree with me, the Divorce Act wouldn't even apply to these people.
Right.
Because the Divorce Act only applies to those people in Canada that are married. So if they're common law, what's the law for a common law people in that circumstance?
Well, in Ontario, it would be the Family Law Act. And in British Columbia, it's also called the Family Law Act, which is what Michel and Graydon deals with. It's Section 152 of the Family Law Act, of the British Columbia Family Law Act.
And what did they find with respect to that?
So the Supreme Court of Canada found that that section of the Family Law Act does not necessarily preclude courts from ordering child support in situations where children have aged out of that category of child of the marriage.
So what I find fascinating is it's quite common that the federal government and provincial governments try to talk to one another with respect to amendments dealing with custody, access, child support, and spousal support. Because the Divorce Act, as I said before, applies to married people. And the Family Law Act in Ontario applies to common law people. But there seems to be something intuitively that would be unfair, that if I'm married, I may get one amount of child support or spousal support, something different for a couple that didn't get married. So it's very common that the two governments talk to one another. And if you even look at the upcoming amendments of the Divorce Act that are coming into force on March 1, the reason they were delayed was because provinces like Ontario didn't have the opportunity to try and mirror the legislation because of COVID. And they're in the process of doing that. That's why the federal child support guidelines are the exact same dollar for dollar as the provincial child support guidelines, and the wording almost mirrors one another. Why I say that as background for our viewers is that, and this is one of the things that the Supreme Court of Canada is really critical about, is to say, don't just automatically assume that the federal legislation and the provincial legislation is the same. So therefore, a common law couple in BC may have a right to make a retroactive claim. It doesn't necessarily mean that a common law couple in Ontario can make that same claim. And did you look at the Family Law Act from that perspective at all?
I did slightly, but I mean, I would assume that courts in Ontario are going to try and adopt this new sort of principle and sort of find a way to make it work in Ontario as well from just a fairness perspective, because I think what the underlying principle in all of this is that you don't want payors to be able to skirt their responsibilities in terms of child support. And you and I see all the time, if there's anything that courts are highly critical about, it's about protecting children's interests and children's rights. And so from a child's rights perspective, where child support is supposed to be a right of the child, I can see courts coming down, even in Ontario, on payors who try to abdicate their responsibilities by hiding their income or not reporting their income or not sort of following the rules and the guidelines with disclosing income and income changes on a yearly basis.
Well, it's interesting. I always remember when I was a young lawyer, I was at a conference, and one of the senior judges from the Toronto area who did a lot of family law cases said, judges try to do what's right and then make the law fit. Now, the problem I have with that is when I read the Ontario Family Law Act, it has its own wording and own definitions, but it certainly appears that in order to apply for support under the Family Law Act, the child needs to be in that act, it's called a dependent at the time of the claim. So I think if you did a statutory interpretation, I believe the result is if you're common law in Ontario, you're out of luck. That does not mean that a court is not going to want to find something creative to have it mirror the Divorce Act. And that's just my view on reading of the statutory interpretation without really digging into it and digging deep to see if there's another way to come up with the statutory interpretation that I may not have thought of, or some creative cases that assist with statutory interpretation, because there may be something along those lines that will sort of push that along. But that's a concern that I would have. And the reason why I say it's a concern, and I think it's important to note it and realize it, is I don't want our viewers to think, great, I saw the Ask Andrew show, I have a child support, my child is graduating from university in 2 months and isn't going to be a child anymore, so I don't need to worry about the limitation period. Boom, I can wait on it. I saw Ask Andrew. First of all, we waive all liability. We're not your lawyers on the show. I have to throw that in. I'm a lawyer. We give a warning at the end, so please note it. But in any event, not just about our liability, it's about you understanding where you stand. I wouldn't rely on this case as a reason to advance that argument. What I'm really saying is, if you're close to the deadline and it's coming up, don't sit on it because Michel and Graydon said it's okay. Go to court in any event. Go protect yourself. This is a Supreme Court of Canada decision, but we haven't seen the interpretations of trial decisions on it yet. And there may be other technical flaws that we could get into with waiting on it. So even though this does change the limitation period, don't just sit back, relax, and wait on it. It's not necessarily the best move to make, because you may find out that you're surprised on an interpretation basis. I also noticed, I'm going to circle back on this a little bit, but we as lawyers have always gone on this 3-year rule that we mentioned earlier. And we always talked about if you want to go beyond blameworthy conduct. And I seem to recall at least one of the 3 decisions one of the minority decisions talking about changing that standard of blameworthy conduct. Did you notice that in the reasons?
I did not know.
Okay, so it seems that one of the judges, or at least two of them, I guess, from concurring, is talking about how you look at the blameworthy conduct, and was it reasonable? Is it necessarily the only thing? They're bringing in more to it, and you can see it's almost going to what you said, which is, let's just make sure people have paid what's right. And this was also a case that screamed out for it. And why I say it's a case that screamed out for it stems from your comment earlier. The recipient was on social assistance. And I query if the decision would have been different if it was a difference of the payor, say, making $500,000 a year versus 530 or 500,000 a year, and having paid child support on a table amount of 500,000 a year. Would the court have looked at it and said, we don't feel bad. The children were well taken care of. That's plenty of child support. Right? And whether he made that money or not, it was a close call, but not been too concerned and come down a little harder on the recipient for not doing something to be proactive, because that's one of the other things. Did you notice in the decision about the recipient? Used to be the recipient, as I understand it, used to have to explain why they didn't do anything for all these years. Did you notice how the court dealt with the recipient and how far, and them needing to explain why they didn't do anything for so long?
Well, I think the recipient in this situation did have a reason. I can't remember right at the top of my head what the reason was, but in one of the reasons, there was a sort of affirmation that, she did have adequate reason for waiting as long as she did to bring this claim. And then you couple that sort of with her own financial situation. We see this all the time. Sometimes clients don't have the funds to be able to afford a lawyer to be able to seek out retroactive child support. And as you mentioned earlier, if someone comes in the door and says, they believe they're owed retroactive child support, and we do some preliminary calculations, and we find that there's around $20,000 or $23,000 owing, it becomes a little bit of a cost benefit analysis, right? How much are you willing to spend in legal fees to see some of that or all of that back?
Well, certainly there was more time and legal fees spent on this case than what the fight was all about. But we see a lot of these cases where we go back, whether it's 3 years, 5 years, 8 years, 10 years, that can be very challenging with how far back you go. This may tell lawyers that we have to think about our offers to settle in cases that are out there where we've only gone back 3 years, that maybe we should be going back further than 3 years now in light of this particular decision. But I also look at it and see it as somewhat problematic, because we also talk about family law of wanting somewhere there to be some certainty, some end of the line, I don't need to be worried. Somebody is always looking over my shoulder. At what point are we saying to people that the litigation should come to an end? At what point are we not being so paternalistic that we're saying, we'll give you a chance to do this forever? Because the other problem that happens, there's a common law term called laches. And what laches talks about is delay. So the problem is, if somebody is asking me for support from 10 years ago, most people don't have their records from 10 years ago. CRA doesn't expect you to keep your financial records. So it becomes a much more difficult exercise. And is it a question of the person gave the financial information and the recipient didn't ask the questions they should have asked? Or was it something that was more deceptive, or they didn't give the disclosure and just gave a figure? And if they just gave a figure, should the recipient take responsibility for not asking for the disclosure? I think the case law is clear now that there's the obligation to disclose. It doesn't have to be asked for, it should be given. But the question becomes, how much is the amount that you've given to discharge your obligation, and in essence throw it to the other side that they should have dug further? All interesting points that we don't have the time to dig into today and get to the answers. And then also there's another case that's going to be coming up in the future, which is, what happens if this is the reverse? What happens if this is an overpayment? And now the payor is going to the recipient and saying to the recipient, I've overpaid for the last 10, 11 years. How is that going to play out?
Well, there's a decision coming out later this year, I believe, and so you and I might want to analyze that decision in a few months. I believe that's coming out from the Supreme Court of Canada in a few months later this year.
And
it's
and
called Colucci.
And I think that'll be very interesting development to see how the court deals with that. But the real challenge I have when the courts are going back 11 years like this, and I'm going to be somewhat critical of the Supreme Court right now, is in my mind, they don't appreciate what the practice of family law really is. And they sit there and they have in their reasons for decision sometimes some very complex reasons. And then by the same token, they'll complain about access to justice and not give any thought to the fact that their reasons have significant impact on access to justice because they make things that much more complicated. And when you're opening the doors up to 10 years back, I can see a client's going to say to me when we're negotiating a deal, okay, Andrew, I'm doing my deal on child support now. And I want to know that it's going to be a final deal and I'm not going to have to worry about anybody coming back at me, and I'll give the annual disclosure. And now we're going to look at clients and say, I don't know how far back they may be able to come. And that's a scary thing for people. And that only in a way can create more litigation, because you're going to get some litigants now who are going to say, aha, I know he's been lying to me the last 15 years, or she's been lying to me the last 15 years, and I want to go back. I mean, what's your sense on that?
I see where you're coming from. I think what you raise from a payor's perspective is very interesting. But when you look at it from a recipient's perspective, I think this sort of hard deadline of 3 years, I see a lot of my recipient clients have problems with that, because sometimes they don't know that they have a right to an annual review of child support. And by the time they realize it, it's been 5 or 6 or 8 years and they haven't received the child support that they believe they were due. So I think it can go both ways. And I think if we look at it sort of from a fairness perspective, it's a little bit of a balancing act, right? You have to look at it from the fairness of sort of to the child and the recipient and sort of what they are owed rightfully, and then also balance it against the payor sort of side of it and see what would be considered fair in their situation. And I think it's always a lot of what we do, especially with things like child support, when we're looking at it retroactively, is a little bit of a balancing act and trying to figure out what sort of happy medium makes the most sense from a fairness perspective.
And understand, I look at a very significant distinction between a case when someone has given financial disclosure each and every year and they've done a recalculation, then somebody takes them to court a number of years later and says, you wrote off a whole bunch of expenses you shouldn't have written off. To me, that's the kind of case where I have a problem with them going back 10, 11 years versus the case of the payor doesn't give any disclosure, or the disclosure the payor gave was just patently wrong. i.e., they've doctored them, they haven't given all the information, they've played games. Those are two very different things, because I look at it and say that if I'm a recipient and I got my payor's disclosure and I looked at it and I thought, wow, this doesn't make sense, it's on me to do something on a somewhat timely of a basis, versus I never got the disclosure, and because I didn't get the disclosure, they missed their obligation of what they're supposed to do. And in essence, I'll equate it to a limitation period to say the limitation period doesn't start to run until the disclosure is given.
Absolutely. I think you're totally right. And I think what shouldn't be lost, and correct me if I'm wrong, but I don't think Michel and Graydon really changes that principle of 3 years necessarily, because I think in order to go past 3 years, you would still need to demonstrate some sort of blameworthy conduct. And you and I see it all the time, and that conduct would need to be egregious if you're going back, if you're looking to go back 10 or 11 years. So I don't think you can necessarily rely on Michel and Graydon in saying that it's sort of a blanket approval for everyone to always get retroactive support for as far back as they want it.
Except it lowered the threshold from blameworthy conduct. It did bring it down slightly. I see we have a question, or it's more of a comment from Dave Brewster. He commented on YouTube, good teamwork on the analysis. So I want to say thanks, Dave, much appreciated. But where I'm coming from on this is, I guess I'm a believer in personal responsibility. And to a certain extent, I think we as society is trying to look a lot less at personal responsibility now than we have historically. And I think the personal responsibility of the payor is produce the disclosure, give it. The personal responsibility of the recipient is, if I don't like the disclosure I got, ask the questions. Ask the questions when you get it. And there should be a point in time, subject to basically a fraud, that the clock starts running. And I'm concerned that this opens the floodgates. And the problem with this kind of opening the floodgates, ironically, it's probably good for people like you and I because it's going to be more litigation. But the practical reality is people need it to end at some point. It's family law. These people who are usually having these kind of issues, they have children. And these are about the children that have aged out and are no longer children of the marriage now. And they're moving on to stages of weddings, grandchildren. You'd like to think that the parties are moving on by that point in time. And if people are moving on, this doesn't help it when you have two parents that are going to go to a university graduation, or they're going to go to the wedding of their children who are now 28 years old and getting married, and still be in the throes of litigation over child support from 12 years ago. And that's where it goes back to the concept of, I don't believe the Supreme Court of Canada always looks at the bigger picture. I'll give an example, is Contino. Now, some of our viewers may know what Contino is. It's the decision that deals with set-off child support. And that case started in Newmarket in front of a judge who's retired now, I regularly appeared in front of. And she viewed that case on a busy motions day. At the time, Newmarket could have had 20 matters on that judge's docket. And she looked at the case, which was the children were roughly 50-50, and said, well, let's look at what one payor has to pay in the guidelines. Let's look at what the other one has to pay on the guidelines. You just do the math and it's a difference. By the time it gets to the Supreme Court of Canada, we get an incredibly lengthy decision that talks about you start where the judge started it in Newmarket, but then you go do this very lengthy analysis. And the irony is, I've heard judges say this, mediators say it, experienced lawyers all say it. You can ask 20 of us as to how to deal with child support in a shared regime under a certain fact pattern. We don't get it. We don't have a real answer. There isn't any unanimity, and there isn't much of a majority. In fact, you're supposed to do now child care budgets for that. And I say that because here we have the Supreme Court of Canada who talks about access to justice, who is dealing with an issue that happens every day and gives a decision that doesn't give a directive to judges who are hearing the cases every day at the trial level of how to do this in a cost-effective way. Instead, what they've done is they've turned it into something that's a mammoth that nobody knows the answer and is going to cost way more legal fees. And I think they've done something similar here today with this particular, well, not today, but in this particular decision, I think they've done something that is going to create a lot more litigation and conflict. And if the Supreme Court of Canada should really be thinking about if they do care about access to justice, which is what they say they do, then they should be trying to give us something that is far more simple so that we can give easier and more straightforward advice to our clients with more certainty to our clients so they can govern their lives accordingly. And that's one of my big problems in terms of family law, what I see the Supreme Court of Canada doing when they get cases dealing with family law. I don't know if you want to weigh in. We're almost out of time, but do you want to weigh in?
I think the only thing I would like to bring up, and I think our viewers should keep this in mind, is when you're looking at retroactive child support, depending on how far back you're looking to go back, it's not an easy endeavor, right? I mean, we run into issues all the time about documentary evidence. You mentioned that, people don't usually keep records, and that's so true. If you don't have the records, if you don't have the income disclosure, when you're self-employed, the business disclosure, it becomes, like you said, a mammoth of a thing to have to deal with what somebody's income was historically, what sort of the expenses were historically, when you're talking about Section 7 expenses. So for the most part, regardless of what this new Supreme Court of Canada decision stands for, I think the thing that our viewers should know is if you're looking to bring any sort of claim for child support, whether it's ongoing or retroactive, you want to do it as soon as possible. You don't want to wait. There is sort of no better time than the present. And I think I would assume that you would agree with me on that.
I do agree with you. I want to note we have a question where it says, what if the payor refuses to disclose even though a support deduction order is in place? Regrettably, then you're going to have to go to court to get an order for disclosure. But my point is really, really simple. If there hasn't been disclosure, I agree wholeheartedly. Without disclosure, the timeline shouldn't start. You shouldn't be able to say, oh, you shouldn't come back 10 years, but I never gave you any disclosure. That I have a real problem with. But when somebody is given the disclosure for 10 years, and then the recipient says, oh, by the way, I want 10 years, going back 10 years, I see a real problem with that. So I know that we're basically out of time right now. I hope our viewers enjoyed the topic of this show. Shazia, I want to say thank you for joining us. I know it's the first time you've been on the show. It was a pleasure having you. You did a great job. The next Ask Andrew show is on November 16th at 1:00 p.m. If you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.